Today, we have 6 experts from different jurisdictions discussing the very interesting issues about ADR. ADR should have been a very flexible and speedy approach compared with litigation. However, facing the challenges and various issues and obstacles created by the courts of different jurisdictions and even by the arbitration practitioners, we have to constantly review those issues so as to make ADR still the winner when comes to the beauty contest. So now we will have our first speaker, Mr. John Arthur. Mr. Arthur is a barrister with the Victorian Bar. He's a fellow of the CIARB, and he's a very experienced arbitrator and a mediator. So let's welcome John.
Awards may be contrary to public policy where there is illegality or where there has been a breach of natural justice or fraud or corruption on the part of the arbitral tribunal. The meaning of the term public policy has been clarified in the Australian International Arbitration Act, which is the Lex Arbitrae of Australia. And the clarification is also reflected in many of the other Lex Arbitraes of model law countries in the region. The concept of public policy is an international thing, and it really comes down to a violation of really fundamental conceptions of legal order in the country concerned, or norms that embody and reflect fundamental notions of morality and justice. The law in relation to the setting aside of non-enforcement of arbitral awards has recently been clarified in Australia in the TCL case. I'll leave delegates to look at the facts later, because the main point that I wish to derive from this case is the ratio of this case, which is that an award made in ICA will not be set aside or denied recognition or enforcement by reference to the principles of natural justice or procedural fairness unless there exists real unfairness or real practical injustice. Now, in getting to that point, and this is the other sort of take-home message, perhaps, of my paper, is the court emphasised that in interpreting Australia's Lex Arbitrae, it was important to establish and maintain, insofar as the language permits, a degree of harmony and concordance of approach to ICI by reference to the jurisprudence of common law countries in the region.
If one were to look at how intentional these procedures are in the various arbitration regimes and international rules, for example, if one were to look at Article 21 of the ICC rules, it basically provides that the arbitral tribunal shall proceed within as short a time as possible to establish the facts of the case by all appropriate means. If one were to look at the LCIA rules, it has a similar broad exposition to conduct such inquiries as may appear to the arbitral tribunal to be necessary or expedient. You have that in the UNCITRAL rules. Ladies and gentlemen, you will immediately note that it's kept wide. It's left to the parties, promoting this hallmark of arbitration, which is party autonomy and consensual approach, for them to decide what is appropriate for their specific case in advancing the cause of justice. So I think then the question is a specific procedure required without tying the hands of the parties in carrying out a proper and effective arbitration in the international scene?
Now, in Sri Lanka, there are 2 judgments which I have quoted extensively in my paper where that principle has been applied. In India, it has gone from being a very restrictive interpretation to a very liberal, wide interpretation of what public policy is, then back to a very restricted, narrow interpretation, and now the latest position is again, it has opened up, and a very liberal interpretation of public policy has been given. Now, one other aspect that I have addressed is that what is set out in the model law as well as the Sri Lankan arbitration law, and since we are only talking about Sri Lanka and India, the Indian Arbitration Act, is that the grounds to set aside an award is on questions of process.
Mediation works very well at community level. Many lawyers are not aware of how community mediation boards work, pretty much because they're not part of it. But in terms of people's access to justice, mediation boards attract over 100,000 disputes every year, record a settlement rate of 50 to 60%, which is quite good in terms of mediation. And people from all walks of life do go to community mediation. In that sense, it's a system that works very well in Sri Lanka.
The most fundamental argument against investor-state dispute settlement is that it subverts the rule of law so laboriously constructed over the past 200 years by attempting to privatize justice. The establishment of a parallel system of dispute settlement which is not transparent, accountable, or even independent cannot be tolerated.
So talk about how we do how does court mediation work in our High Court or the Supreme Court. In our case management meetings or pre-trial conferences, I think from the word go, once the read is filed and the pleadings are closed, to file your defense and your replies and things like that, the courts then start to get to ask the lawyers, how about going for mediation? Try and resolve this thing.
What is the reason for this? One of the analysis that has been done seems to suggest that many of them relate to procedural issues. Service of summons. Sometimes it takes months to serve summons on a person. Sometimes summons is not served at all, and what do you do with the case? How do you progress with the case if the summons is not served? Very often pleadings were not being completed in time. A written statement, for example, was not being filed in time. Or there would be an amendment to the written statement or an amendment to the plaint. So there would be these kind of procedural issues. And the biggest villain was adjournments. They were being granted, they were being sought for the asking, and they were being granted for the asking.